My name is Amanda Johnston and I am a Senior Associate here at Michael Lynch Family Lawyers. So thank you for joining me today for this presentation on children's wishes and how they are ascertained in family law. Now, before we get started on today's topic, I'll just tell you a little bit about our firm. So Michael Lynch Family Lawyers is a specialist family law firm that has been established for over 25 years. Now, we have 16 lawyers, 5 of who are accredited family law specialists and who can all provide assistance. We offer fixed fee, no obligation initial consultations to allow people to obtain advice and gain an understanding of how the law works in their particular matter. Now, today we will be looking at children's wishes and how they are ascertained in family law. Specifically, we will be examining the following key areas. What age does a child need to be? How do children's wishes fit within the legislative framework? How are children's wishes captured by the court? What if parents' views differ about the child's wishes? What the role of an ICL is? The purpose of a family report? What weight is to be placed upon a child's wishes? Child inclusive mediation? We'll examine some recent case law which deals with children's wishes and what this all actually means in practice. Now, what age does a child need to be? So many people come to their lawyer and they ask the same question. What age does my child have to be to decide where they want to live? Now, this is often followed by a statement that they have read something somewhere that tells them 12 years of age and that they want to confirm that that's correct. Now, other times they've had discussions with well-meaning friends, family, or people on the internet regarding their family law matter, and they are told differing information based on those other people's experiences within the family law system. Others just hold the view that surely a judge would not force them to spend time with the other parent when they do not want to. Now, despite what people have read or heard, they are often shocked to learn that there is no set age for when a child can choose where they want to live and what time, if any, they want to spend with the other parent until they turn 18 years of age. Now, notwithstanding this, there are various ways that a child's wishes can be expressed in the family law system, and there are many factors that are taken into consideration when assessing their wishes, which we'll talk about today. So how do their wishes fit within the legislative framework? Article 12 of the Convention on the Rights of a Child states that parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters which affect the child, and the views of the child being given due weight in accordance with the age and maturity of that child. Now, for this purpose, the child shall, in particular, be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body in a manner consistent with the procedural rules of national law. Now, in essence, this provides for every child to have the right to express their views, feelings, and wishes in all matters which affect them, and to have those views considered and taken seriously, and for those rights to apply at all times, including in decisions such as the child's housing and day-to-day life. Now, these rights of a child have been reinforced through the Family Law Act. Now, Section 60CA of the Act specifically states that a child's best interests are the paramount consideration for the court when considering making parenting orders. Now, when looking at a child's best interests, the court must have regard to both the primary and additional considerations which are set out in Section 60CC of the Family Law Act. Now, the primary considerations are the benefit of a child having a meaningful relationship with both parents and the need to protect a child from harm. It is important to note there that the right of the child to have that benefit of a meaningful relationship with both parents does come secondary to the need to protect a child from harm. Now, the additional considerations can include, but are not limited to, any views expressed by the child and any factors such as the child's maturity or their level of understanding that the court thinks are relevant to the weight it should give to those child's views. Now, it's really important to be aware that a child cannot be forced to express their views or wishes at any time in a family law matter. So how does the court inform itself of a child's wishes? Now, people often ask if a child can provide an affidavit or attend court and give evidence, and generally the answer to this is no. Now, children's wishes can be presented to the court in the following ways. So in a parent's affidavit or other witness, such as a step-parent, where the party sets out what the child has told them and how this has occurred. It can be by a judge speaking directly to a child. However, this is rarely, if ever, done in Australia. By an application from the child seeking to be joined as a party to the proceedings. By an appointed independent children's lawyer who speaks directly with the child, and by way of a family report conducted by an independent family consultant. Now, generally, when a parent or other party files material in family law proceedings, they often set out the evidence that they say supports their case, which can include things such as conversations that the children have had with them or things the children might have expressed. It can also include observations of the children and the other parent, such as how they interact at changeover, for example. Now, it is not uncommon for the parents or another party filing material to have a differing account of what the child has said to them or how things have been going between them. However, simply because parents' statements on a child's views differ, it does not mean that the court places greater weight upon one parent. So neither parent's rights are more important than the others. Now, the Family Law Act makes it really clear that both parents are responsible for the care and welfare of their children until the child reaches 18 years of age, and that there is the presumption that arrangements which involve that shared responsibilities and cooperation between the parents are in the best interests of the child. Now, where parties are seeking to put information in their affidavit regarding a child's views, it is really important to consider the context in which those comments were made or the interactions were observed. For example, a child may seem upset at the prospect of spending time with the other parent, but it may simply be because they know the other parent is going to do something fun, such as going to the movies, and they don't want to miss out on that activity. So it's not that they're upset at seeing the other parent, it's just they don't want to miss out on something fun. Now, similarly, when considering views a child may have expressly stated to a parent or another party, it's really important to consider how those views were expressed and the context in which this occurred. Now, a court will want to know how statements came about and not simply accept the party saying what the child has said as the truth. Further, they'll really want to know how those child's views came about and that they weren't influenced in some way, and ensure that the parents remained neutral and supportive of the other parent during such conversations. Now, in the context of a child's views being expressed, it's also really useful for the other parent hearing this, as they may not readily accept what they are being told the child is saying. In fact, they may think that the other parent is influencing the child in some way or pressuring them to express a particular view. So that context is really important. Children can also feel compelled at times to say what they think the other parent wants to hear. And so if the views expressed were after being sat down, after returning from spending time with that other parent and being questioned for an hour, they may not really carry any weight. So again, it really is that context of how and when the conversations were had that is really important in these situations where a child's view is being expressed through a parent's affidavit. This can also allow an additional layer to be given to the evidence and give the court that greater ability to consider the weight they will place on the evidence as its context is fully explained. Now, it is important to note that children cannot provide affidavit evidence on their own without the court's prior leave, except where they seek to be joined as a party. Now, they also cannot be called as a witness or be present during the proceedings without a court order allowing them to do so. This is a really important feature of the family law system, as it ensures children are protected and they're not brought into the proceedings unnecessarily. Now, another way that children's wishes are heard can be by a judge speaking directly to the children. However, unlike what we see on television and in movies, this is an exceptionally rare practice, and it's not encouraged and rarely, if ever, used in Australian courts. Now, similar to what was said above, this is a really important feature in our system to ensure children do not become entangled in their parents' dispute and the proceedings unnecessarily. Now, another way is by a child seeking to be joined to the proceedings. So the Family Law Act provides for third parties to seek to be joined to proceedings, and it is in this way that a child can also seek to be joined as a party. Now, in order to seek this, the child, having appropriate age and maturity, would instruct their own lawyer to represent them in the proceedings and act on their behalf. Now, this would be a different lawyer to each of their parents, and it would allow them to be heard in the proceedings if they're joined. Now, the lawyer would act on their instructions. They would need to maintain that confidentiality, and they would owe the same duties as they would to any other adult client. Whilst a child could seek representation like an adult, the decision to take the matter on ultimately rests with the lawyer. So if considering accepting the child as a client, the lawyer would need to be satisfied as to the child's maturity and their ability to understand fully what their instructions were and any consequences of those, as well as ensuring that the child was instructing them of their own free will and volition. Now, generally speaking, most lawyers would not accept to represent a child who sought to be joined to a family law dispute without some form of independent third-party evidence regarding a child's maturity. So whilst children seeking to be joined is an option, like judges speaking directly to a child, it rarely, if ever, actually occurs. Now, in proceedings where it is deemed appropriate, the court can, of its own volition or on the application of a party, appoint an independent children's lawyer, and they're commonly known as an ICL. ICLs are lawyers who practice in the area of family law and who have been approved to act as an ICL. Now, there are various reasons why an ICL can be sought. However, some of the reasons for appointing an ICL can include that there are allegations of child abuse, and that can be physical, sexual, or psychological, due to there being an intractable conflict between parties, where the child appears to be alienated from one or both parents, and where there's a child of young maturity who is expressing really strong views, which could lead to a change of residence or no contact with another parent. The other area is where siblings might also be separated. Now, the court does not need to identify the reason of why they've made that order appointing an ICL. Where an ICL is appointed, it's really important to note that they are not the child's direct legal representative, but that they act on their behalf to represent that child's best interests. This means they do not take instructions and place those before the court like a lawyer acting for one of the parents would. So the role of the ICL can be really easily summarised as follows. They need to act independently and unfettered in the best interests of the child. They need to be impartial and, if thought appropriate, make submissions suggesting the adoption by the court of a particular course of action that they consider is in the best interests of the child. They need to inform the court by proper means of the child's wishes in relation to any matter in the proceedings. Now, the ICL is not bound to make submissions on the instructions of a child or otherwise, but they are bound to bring the child's expressed wishes to the attention of the court. They need to arrange for the collation of expert evidence, such as a family report, and ensure that all evidence relevant to the welfare of the child is before the court. They need to test the evidence of the parties and their witnesses to assist the court in determining, well, what is in a child's best interests. They need to ensure that their views and attitudes on the issues before the court are drawn from the evidence and not from their own personal views or opinion of the case. They need to minimise the trauma to the child in proceedings and try to facilitate an agreed resolution between the parents that's in the child's best interests. Now, it is really important to reiterate that the ICL is not the child's legal representative and is not obliged to act on the child's instructions. The ICL must act impartially in dealings with the parties to the proceedings and ensure that any views expressed by the child in relation to matters which the proceedings relate are fully put before the court in an admissible form, such as through a family report. So their key role is to ensure that the children's best interests are identified, promoted and advocated for whilst remaining independent of the parties. Now, the best practice guidelines that were established for ICLs provide them with information regarding their role, how they can build rapport with children, and ensuring children feel heard, not just listened to in proceedings. It also sets out how they may seek to engage in a professional relationship with the child, and informing them of their role, including ensuring the child is aware that the ICL cannot guarantee a confidential relationship with them and the purposes of the proceedings and what things might be happening along the way. Now, it is important that whilst an ICL cannot guarantee a confidential relationship, they should aim to develop a relationship of trust and respect to ensure that the child is aware how they can have a say, and again, through things such as a family report. Now, in some states, ICLs will meet with children as common practice, whereas in others, such as Queensland, it is more limited. However, if the child is of an appropriate age and maturity, they may meet with them. Now, generally speaking, if an ICL is meeting with the child will usually be in their teenage years. Now, where ICLs are advised, whether directly by a child if they have met with them, through reading a family report, or through material that's been filed by the parties regarding the child's wishes, they still need to analyse those wishes stated, and they need to keep in mind that each child will generally be at a different emotional, cognitive and intellectual development and may have a differing family dynamic and structure. Their sibling relationships will have an impact, as well as the religious and cultural background, even where they do come from the same family. Therefore, some might be more vulnerable to some of those external pressures. Even where children do come from the same family, they can also have a different experience and a really different and unique way of expressing themselves to their siblings. Now, it should be noted that whilst an ICL does remain independent, upon consideration of the evidence, including any views expressed by the child, the ICL may take a view that is consistent with one of the parties in relation to the child or with the wishes expressed by the child. Now, another way that the child's wishes are put before the court is through a family report conducted by a family consultant. So this can be arranged by the ICL or by the parties privately through jointly appointing a single expert, or of the court's own volition. So where the court makes an order for a family report, the parties are required to attend, and the parent with the children must bring them to the consultant as well. So family consultants are psychologists or social workers who specialise in child and family issues after separation or divorce, and they're approved by the court. So it's important to point out, though, that parties do not actually need to have court proceedings afoot in order to obtain a family report. So they can get one privately by jointly appointing a family consultant and paying their fees. Where there are proceedings afoot, the family consultant will be given copies of all filed material, and they can be given access to material produced under subpoena as well. Now, the family consultant will interview all relevant parties, and that can include new partners as well as the parents and children. So the parents will usually be interviewed separately, then the children can be interviewed pending their ages and whether or not the consultant deems it appropriate in the matter. And they can then observe the children's interactions with each parent as well. Now, unless it is not appropriate to do so, such as due to a child's age, or if they have a disability, a family consultant must ascertain the child's views in relation to the matter and include such views in the report. However, it's really important to point out they cannot compel a child to express a view or wish. Now, another important aspect of the family report is that where parents' affidavits have set out a child's views, the family consultant can also explore that with the child and try to ascertain whether the child has the maturity for those views, whether they fully understand those views being expressed, and help consider whether those views are legitimately held rather than being due to the influence of a parent, for example. Now, this can add further weight to those views as well if the family consultant deems that the child's views are well-founded and understood, and this can be reflected in the report. Now, the family report process usually takes 1 day to complete, and then a detailed report is prepared by the family consultant, and it's released around 6 to 8 weeks later. And that report will set out each party's position, any issues for the family unit, and it will make some recommendations about how parties could proceed that best supports the children's interests and deals with any issues for the family. Now, recommendations can include things such as what time might be appropriate with each parent, but it can also include whether parties should attend counselling, for example. Now, family reports are usually held in high regard by the court as they provide truly independent evidence, and they highlight issues for all parties and the family as a whole. Now, whilst the report recommendations do not necessarily mean that that will be the outcome of the proceedings, they do carry significant weight, and often the recommendations can be the orders made by the court or even by agreement between the parties prior to reaching a final hearing. Now, in the 1997 National Inquiry of the Australian Law Reform Commission, it found that in at least 60% of cases, a family report was ordered. Given the time since that inquiry and the new court system, which seeks to achieve faster resolutions for families, it is likely that that figure is much higher today. The inquiry also set out the highly influential nature of a family report, and that in 76% of cases, judges followed the recommendations that were made. So as you can see, a family report really carries significant weight in parenting proceedings due to its independent nature and its ability to highlight the issues, any views and recommendations regarding a child's best interests. Now, when considering the weight that should be applied to children's wishes expressed by a child, the judge, the ICL and the family consultant will consider the following factors. What is the child's degree of emotional and intellectual maturity? The apparent strength of those wishes, whether their wishes have a sound, rational base, and what is influencing those wishes, if anything, and is it wholly or partly due to manipulation by a parent or other significant person in the child's life. Now, when considering what weight should be placed on the child's wishes, the judge, ICL, and family consultant will consider the following things. What is the likely impact on the child if their wishes are given significant weight? What is the likely impact on the child if their wishes are not given significant weight? And where there is more than one child, whether there are any competing or divergent wishes, such as siblings having a different view. So whilst children's wishes are important and they can have a significant impact on the outcome of proceedings, they are only one of the many factors that the court considers when dealing with parenting matters. So ultimately, the weight to be given to a child's wishes is at the judge's discretion, and they are not obligated to make orders consistent with a child's wishes and views, but rather they're obligated to consider the weight to be given to those stated wishes. Now, this is really important to make clients aware of in family law matters, that simply because a child might be expressing a view, it does not mean that that will be the outcome, and it is still at the judge's discretion. Further, different judges might place different degrees of weight on a child's wishes, so it is a really discretionary area. This is also the same with the family report and any recommendations made. It is ultimately up to the judge to decide, well, what is in the child's best interests, and this may not be consistent with the recommendations of a family report. The judge will have regard to all of the evidence before them, both independent and that of the parties, when they're considering that appropriate outcome. Now, another area that we'll touch on briefly is that of relocation. So relocation of children is an area that sometimes people think is viewed a bit differently to a general everyday parenting matter. However, it is not. They don't require anything further to be considered that's special other than a normal parenting matter, and the court is still required to consider those same factors, including the child's wishes, in the same way they would any other matter. However, a relocation matter is often a bit more intense in that the relocation sought, it might be quite significant, such as to a new state or a country, which may have a huge impact on whether children were to move or change residence as a result of the parent moving. So it's just really important to bring that to your attention, as relocation matters are treated the same and the evidence will be collected in that same manner. Now, an alternative way that children's wishes can be obtained, and this is more so by the parties outside of proceedings, is through engaging in child-inclusive mediation. So this is different to a child-focused mediation where parents attend with a family dispute resolution practitioner and they try to reach a suitable outcome. Now, child-inclusive mediation can be sought at any time, including if proceedings have already been commenced. Child-inclusive mediation involves the child to the extent that their voice is heard by the parents through a trained child consultant, but they are not part of the mediation. So a key factor in child-inclusive mediation is to ensure that whilst the child's voice is heard, they are not responsible for the decisions that are made. So it is not a practice that seeks to have the child say where they want to live and how many nights that they want to see the other parent, but rather it focuses on ascertaining the child's wishes and needs, such as ensuring they get to spend time with both parents, having both parents attend at their special events, such as dancing and swimming and that sort of thing. So the child's needs and wishes will differ in every case. Now, another key aspect of child-inclusive mediation is that before it can be deemed appropriate, both parents must be willing and able to hear what the child consultant has to say without it causing the child any harm. So if there is a concern that after the child's wishes are made known to the parents, the child will suffer harm of any type by one or both parents, then child-inclusive mediation is not appropriate. Now, the final decision regarding whether or not child-inclusive mediation is appropriate will rest with the child consultant and mediator, regardless of the party's willingness to engage in that process. So what happens at an interim hearing? Where parenting proceedings are commenced, the matter will usually have an interim and a final hearing if it does not resolve along the way. Now, what happens at an interim and final hearing will be different, and the way in which children's wishes are dealt with at each can also be different. So interim hearings are held when parents cannot agree on arrangements for their children or property matters, and the court needs to make some temporary orders or an order that certain steps be taken before a final decision can be made. Now, interim orders remain in place until further orders are made or there's an agreement reached between the parties. An interim hearing may take place on the first court date, which is allocated when the application is filed with the court, or it can occur after a mention or some other court event or procedure. Parties will be informed, though, that the matter has been or is going to be listed for an interim hearing so that they are prepared. Now, usually the evidence available for a court to consider and rely upon at an interim hearing is the evidence contained in each party's court documents, such as any affidavits of the parties or their witnesses, any annexures to affidavits, and information contained in a party's notice of risk or financial statements. Now, other evidence that may be available for the court and the parties to rely upon is documents produced under subpoena from a third party or documents that are produced pursuant to Section 69ZW of the Family Law Act. Now, Section 69ZW allows for the court to seek documents that are directly related to the children from child safety and from police to allow for that independent evidence to be available where it's considered necessary at an interim stage. And this information is made available to the parties in the same way as a subpoena, and it can be relied upon the same as well. The main difference between a subpoena and a Section 69ZW order is really that a subpoena requires one party to issue it, pay a fee and serve it on that relevant party, whereas a 69ZW order is done by the court, so no party needs to pay for it. Now, this is important as when we're considering how a child's wishes can be conveyed to the court, we need to consider what the best way is to do this, such as through the parent's affidavit or that external evidence such as subpoenaed material. Now, subpoenas might include seeking information from the child's school or daycare, and it could also be that a party seeks a letter from their counsellor or the child's treating GP. So by providing that best evidence that's available at the time regarding a child's wishes, the court is in a better position when they're considering interim arrangements and what weight they may give to any wishes expressed by a child. Now, normally the court does not require nor allow any person to give oral evidence at an interim hearing. However, cross-examination does occur at a final hearing. Therefore, it is highly unlikely that a party would be required to answer any questions in the witness box or be required to ask questions of the other party. Now, despite this, sometimes a judge will require additional information or clarification from a party. So they may ask questions that can be answered by a party or their solicitor, but they're not formally considered as evidence in the matter. So this just highlights the importance of ensuring that all evidence and the best evidence that can be provided is given to the court in that admissible form, such as by way of an affidavit or an annexure to an affidavit, so that the court can consider it and take into account. Now, what the court can't do at an interim hearing. So at an interim hearing, the court cannot make findings of facts where facts are in dispute. So an example of this is where a party alleges that one party uses physical discipline on the children and the other party disagrees, but they might make the same allegation against that first parent. The court cannot determine which allegation is true at an interim hearing. They can only make findings of fact at a final hearing after hearing and testing all of the evidence, including through cross-examination. Now, secondly, the court can only make orders about certain types of issues, being those that they have the power to deal with under the Family Law Act and any regulations that are in force at that time. So generally, a court can make orders in relation to children or property of the parties, but in the circumstances in which they cannot make orders, might be about child support, for example. That's really limited where they can make orders. The court also cannot make orders about where an adult must live, as well as forcing a parent to spend time with a child where that parent does not wish to do so. Now, a final hearing is conducted by a judge or justice of the Federal Circuit and Family Court of Australia, sitting in either Division 1 or Division 2. Now, prior to a trial or final hearing, parties will have been ordered to file consolidated trial affidavits for themselves and for any witnesses they want to rely upon. Now, at the final hearing, all parties, their witnesses, and any third parties, such as the family consultant, will give evidence and they will be cross-examined in relation to their evidence in their affidavit or report. A barrister, also known as counsel, will be engaged by the party's solicitors to represent that party at trial and conduct the hearing. So counsel will examine the party and their witnesses, and they'll cross-examine the other party and their witnesses as well as the family report writer. Now, counsel will make submissions at the conclusion of the final hearing, and they'll summarise the evidence, what their client's case is, and why the court should make the orders sought by their client. Now, in recent years, a scheme was introduced under Section 102NA of the Family Law Act, and that's in relation to cross-examination of parties where family and domestic violence has been alleged. Now, in those cases where allegations have been made in proceedings and the party accused intends to cross-examine the other party, if they have been charged or convicted of an offence involving violence to that other party, or there is a family violence order, or there has been an injunction order for the party's protection, or the court makes an order regarding cross-examination, that accused party cannot personally cross-examine the other party, and such examination must be done by their legal representative. Now, at the conclusion of a trial, it's really rare that a judge will deliver their judgment on the same day. So usually the judge will reserve judgment and deliver their decision, including any reasons, at a later date. And that's generally 2 or 3 months down the track. So any interim orders that are currently in place continue to remain in force until that final decision is delivered. So whilst there are a large volume of cases filed regarding parenting matters, only around 3% of cases actually make it to a final hearing. So generally, most matters will resolve along the way, including the morning of a trial. Now, before the new court system commenced in September 2021, it often took years for a matter to be able to proceed to a final hearing, particularly when matters were complex and further independent evidence was needed. So whilst the new court structure was introduced in September 2021, which does aim to fast-track matters and have them prepared for a trial within 12 months from the date of filing proceedings, as the system is still really new, it is yet to be seen how and if this can actually work. Now, as practitioners, knowing those delays in the system, as well as the emotional and financial strain it can put on parties, a family report is a really useful way to assist parties in reaching an agreement that can be in the child's best interests. Now, by having that independent third-party report, it can also assist the parties in better understanding the child's wishes or to find some common ground and move forward reaching an agreement and agreeing on final arrangements for their children. Now, to help put all of the information we've talked about so far today into perspective and see how it works in practice, it's useful to have a look at some case law regarding children's wishes. Now, the primary authority in relation to children's wishes is the case of Bondelmont and Bondelmont. Now, it's a 2017 case and it went all the way up to the High Court, which is quite rare. Now, in this case, there were 3 children, 2 sons aged 17 and 15 who both lived with the father, and we had a 12-year-old daughter who lived with the mother, all of who lived in Australia. Now, the father took the 2 sons on a holiday to New York with the mother's consent. However, whilst on holiday, he advised the mother that he had decided to stay in New York indefinitely with the sons, and that the sons had expressed a clear wish to him to remain living with him in New York, and that they did not want to return to Australia. They also had an estranged relationship with the mother, particularly the eldest son. Now, the mother filed an urgent recovery order, seeking that the children be returned to Australia and for the children to live with her. Now, an interim order was made requiring the boys to return to Australia pending a final hearing and further evidence being made available to the court. However, they were not ordered to live with the mother due to those relationship difficulties. Now, the court found it was in the children's best interests to be returned on an interim basis. The court felt it was necessary to have a report prepared which examined more than just the children's views. They sought a report that would examine the children's views, but also the sibling dynamic between the brothers and the sister and the relationships that they each had with their parents. Now, the father appealed the interim decision, and one of the grounds that he appealed under was that appropriate weight was not given to the children's views. The court made it clear that it is not the case that a judge is required to make orders that are consistent with the child's stated views. Rather, they must consider the weight that is to be placed on those views, taking into account a range of factors and what is in the child's best interests. So whilst ultimately on a final basis, the children were able to live with the father in New York, it is important to set out that even at their advanced ages and those expressed views, it was still at the judge's discretion what weight should be placed on those wishes. Now, another case in this area is that of Cortez and Cabrera. Now, it's a 2007 case. In this case, there were 2 children aged 14 and 16, and who were the subject of orders entered into between the parties approximately 10 years earlier. Now, the father brought an application seeking that those earlier orders be varied to move to an equal time arrangement. Now, the basis of his application was that the children had grown older, they had expressed a wish to him to spend more time with him, but they were reluctant to advise a third party or their mother of this, and that the court should have allowed the application as they were old enough to vote with their feet. Now, the court was not satisfied that the father's reasons warranted a reopening of the matter in order to vary the current orders, despite the children's age and wishes he stated they had expressed, nor that a reopening of the matter was actually in the children's best interests. Further, the court stated that parenting orders should not just be varied or discharged according to the whims of children. So this case again really highlights that it is an entirely discretionary area, the weight that is to be placed on a child's wishes, and that it is only one aspect of a parenting matter to be considered when we're looking at their best interests. Now, the next matter of Boyce and Boyce, this is a 2013 case. So in that matter, there were 3 children aged 13, 17 and 18 at the time the matter reached a final hearing. So the court could not make any orders for the 18-year-old, but was asked to consider the time between the 13 and the 17-year-old. Now, the father complained that the mother and her new husband were responsible for the estrangement of him with the 13 and 17-year-old. However, the mother stated she was simply following the children's wishes. The 13-year-old child was deaf and she was resisting time with the father, such that she had not spent any time with the father for 10 months. Now, the real focus in this case was on her wishes. The family consultant formed the view that the mother and her husband were not encouraging the relationship between the father and the child, and that they were allowing that 13-year-old to decide rather than pushing and facilitating a relationship with her father. Now, the family report concluded that whilst the 13-year-old consistently articulated a view that she did not want to spend time with the father, she did not appear to fully understand that view. Now, the judge noted that the mother had willfully and willingly disobeyed court orders by withholding the child from school to prevent the father from collecting the child to spend time together. Now, ultimately, the judge ruled that the 13-year-old child lacked maturity, and therefore those views being expressed had limited weight. Orders were made for regular time between the father and the 13-year-old child. With regard to the 17-year-old, her views were taken on board by the judge, and she was able to make her own arrangements for what time she would spend with the father. Now, this case again sets out that context of wishes and how they are being formed, such as their maturity and understanding, as well as considering any external influences on the child. Now, as the mother was not acting appropriately, the judge was really sceptical of the views she kept stating the child had expressed, coupled with the concerns that the family consultant also expressed. Now, the final case we'll look at today is that of Beckworth and Garnett, and that's a 2017 case. Now, in this case, there were also 3 children, aged 10, 13 and 17. At the time of the interim hearing, the 17-year-old lived with her mother, the 13-year-old lived with the father, and the 10-year-old's time was in dispute between the parents. Now, the 10-year-old wanted more of a say in relation to the time she would spend with each parent. While she was spending time with the mother, she decided that she wanted to remain with the mother, and she began refusing to spend time with the father. The father subsequently filed for a recovery order. Now, he was successful in obtaining a recovery order and having the child placed in his care, and the matter was listed for an interim hearing to determine what next steps needed to be taken. Now, the 10-year-old's evidence was clear that she wanted to live with the mother, and the ICL also shared that opinion that this was appropriate on an interim basis. However, the father sought that the court be cautious and to keep the child with him. The judge highlighted in this case that the child's wishes should be considered and followed. However, that the evidence before the court highlighted that the child's reasons for wanting to stay with the mother were not well-founded or mature. Further, there was no clear evidence regarding any complaints she had in the father's household or that she was unhappy with the father. The judge also noted that the mother had made complaints against the father and lacked insight into her own behaviours and the impact that this may have had on the child. Now, it further came out in the evidence before the court that both the 10 and 17-year-old children had been interviewed by the mother's legal representatives, and the court was outraged by this and ordered that the 10-year-old should remain in the father's care pending further order. So this case again highlights the importance of how the evidence is put before the court, how it is obtained, and looking at the parties' involvement in obtaining that evidence as all being highly relevant, and it will be considered by the court when they're looking at children's wishes and examining those. So what does all of this mean in practice? Children's wishes are important, but they are not the whole picture. They are simply one component of a myriad of factors that the court must take into consideration when determining a child's best interests. So there is no set age until a child is an adult where they can choose where they want to live. Now, despite this, often older children with clearly expressed wishes and insight into the impact of those wishes will in most cases be given significant weight, and if not, they will just vote with their feet. Now, in practice, younger children generally do want to stay with their primary caregiver, whereas older children tend to seek out the house with the most resources, such as technology, gaming consoles, swimming pools, and that sort of thing. They may also seek out the household that is more lenient in terms of household chores and rules as well. Given that older children may say what they want and vote with their feet if not listened to, it is really important for parties to try and work with children to find a balanced outcome. Now, this is obviously more difficult in matters where the separated family unit is really dysfunctional and the parents do not have a good working co-parenting relationship in which they can discuss issues or matters and wishes expressed by the child. There's some things I've learned in practice. There's often caution surrounding a child expressing a view or a wish because children can be people pleasers, particularly in that context of a separated family dynamic. They will often tell parents what they think they want to hear rather than how they truly feel, and they often express a different wish to each parent. So this can be easily seen in conversations. For example, where a parent may say something to a child such as, "You have more fun at my house, don't you?" And the child will usually agree to that statement, even if it's not accurate. Children may also be influenced by the views of a parent, and therefore the view that they are expressing may not necessarily be of their own construction. Children are often lacking in the appropriate maturity to be able to form and articulate a well-reasoned view about their current and future circumstances. And often where parents resist that change for their children, it can do more harm than it does good. Now, finally, not all children will have a clearly defined view, and while almost all children wish to be heard, they generally do not want the pressure or the responsibility to make a decision, nor to be put in a situation where they have to choose, a fact that unfortunately too many parents do fail to understand. So thinking back to our earlier discussions today on both the role of an ICL and the purpose of a family report where children know their expressed views are not confidential, children can often decline to put forward those wishes as they do not want to bear that decision-making burden. Now, this is the same key underpinnings of a child-inclusive mediation, which ensures that children's voices can be heard but are not the deciding voice in their parents' dispute. So it is vital that children are not forced to give a view and they're not put in the middle of their warring parents. Now, in most cases, it is essential to put evidence before the court of the children's views and wishes, particularly as children get older, as their views can carry significant weight and they will be highly relevant to the proceedings and issues for the court's determination. It's also really important to always keep in mind the context in which a child's wishes have been expressed and how that has occurred when putting them forward before a court, and when considering what other independent evidence is needed to assist the parties and the court on satisfying themselves as to the child's expressed views. Thank you all very much for your time today. I do hope you've gained some helpful tips and insightful knowledge in relation to children's wishes and how they are put before the court, as well as ways parties can be advised of same outside of the court process, such as through child-inclusive mediation and obtaining those family reports. Now, if you have any ideas of other topics you'd like to hear more from us on, please feel free to send your ideas through to our main email address at law@mlynch.com.au. We will also send out a feedback survey and we'd really appreciate it if you could do that for us. Thank you again for your time today.